a little bit. Good morning, Your Honors. Mike Middlestadt of the State Appellate Defender's Office, appearing on behalf of Mr. Howard, the appellant in this case. I'm asking the court to grant leave to appeal and or issue an opinion that says three things. First, I'm asking them to issue an opinion that directs courts that the mere fact that a witness hurts her credibility on the stand based on her demeanor and gets caught in a fib on collateral and minor matters isn't the manifest necessity justifying a mistrial. It's not the high degree of necessity for a mistrial. Parties have witnesses who lose credibility on the stand all the time. We don't give parties a do-over just because the case doesn't go as they'd like. We particularly don't do that with regard to prosecutors because one of the whole purposes of the successive prosecution prong of the double jeopardy clause was this practice from England where the prosecutor would get into his or her case, not like how it was going, feel that it was going to go bad on them, they would dismiss and then they would come back with a stronger case. And the only concern that was expressed in this case was the prosecutor saying that, hey, if you fix anything here, it's going to hurt my complainant's credibility. And that's just not manifest necessity. That's a trial. That's what happened at trials. The court should also reaffirm People v. Johnson and its rule as that was affirmed in People v. Benton that mere silence by itself isn't consent. Really, that is just another way of applying this court's decisions in People v. Carter and People v. Carrenas. And overall, the United States v. Alano. Those cases make a distinction between waiver and forfeiture. If you don't assert a right, it's forfeiture. If you agree in some way, manifest agreement, it's waiver. There's really no reason to deviate that in the double jeopardy context, particularly when we have United States v. Dinitz giving a clear direction to our court saying, hey, first and foremost, you have to ensure that the defendant has primary control over his case. Now, primary means first and foremost, overall, over everybody else. A rule that equates silence with consent is, in my mind, inconsistent with such a requirement.
Let me ask you about what's bothering me about this case. It comes to us in this weird posture, right? It's not a case, I'll tell you what I mean by that.
Okay.
It's not a case that we have any record whatsoever from the trial court about whether the defendant consented. I agree with you that silence doesn't equal consent. It also doesn't necessarily equal objection. We kind of need to know more, right? So if defense counsel at trial, we have the record we have, but before retrial had stood up and said, oh, sorry guys, you can't retry my defendant, there's this double jeopardy clause, I imagine the court would have said, what are you talking about? We had that this is possible. We had that conversation in chambers, and you agreed that, you know, it was in your client's interest not to continue with that trial. You wanted, you know, the mistrial. And then we would have a record from which we could evaluate consent. You might not even have brought this issue on appeal. Or the trial court might have said, oh, wow, you're right. I kind of messed up. I didn't get I should have asked, you know, for what your views were, and I didn't. So there's, you know, per this state's case law, you didn't consent. But frankly, there was manifest necessity, and I don't think the record made that clear at the time. Let me make that record now. And then we'd have that to evaluate. In this case, we have neither, which tells me, like, I want more information. So I thought, why wasn't there a Ginther hearing? Why didn't, and so then I went and looked, and you guys didn't ask for a Ginther. Why wouldn't you want a Ginther hearing where you could go back to the trial court, and then we could have testimony about what happened, you know, both in terms of objecting or not to the mistrial, and then why we didn't move to bar the retrial. Well, it makes me think things happened that I don't know about.
Right,
you know?
right. Well, let me address that in a couple of ways. First of all, Johnson and Bennett was in place at the time and said you have to do something affirmatively.
Okay, so maybe there's no strategic. So maybe he didn't. It wasn't ineffective not to object. Fine, right. But he didn't move to bar the retrial either, right? So that might have been ineffective. Which
we are arguing is ineffective.
I know,
and
but I don't have a record from which to like evaluate why he may or may not have done. Maybe he would say, if you had asked for a Ginther hearing and the trial lawyer got on the stand, the trial lawyer might say, I didn't move to bar the retrial because in chambers I had said I wanted the mistrial. If that happened, we wouldn't be here, right?
Right.
So why don't I know what happened?
Oh, let me back up and address that directly.
Okay.
Prosecutor and the trial judge just before declaring a mistrial, went to great pains to make a record. We make a record for a reason, remember? We go back on the record and say, hey, this is what we talked about in chambers, this is what we talked about at sidebar.
I'll give you all that on the mistrial, but the retrial. We have no record on why the lawyer did not move to bar the retrial.
Because you look at consent at the time the mistrial declaration was, I mean, you don't backfill, you don't say, hey, I'm back when I didn't object.
But if I give you consent, we don't have a motion to bar the retrial, so we don't have any record from the trial judge about manifest necessity, right?
Correct, and there is none. There is none. There is not based on a witness line. There just isn't. That's what jury trials do. Now, getting back to my point that the prosecutor went to great pains to put what was on the record with this conversation. Not once did he mention that a mistrial was even discussed. Not once did he mention that the defense attorney said anything. In fact, the first time we heard the word mistrial was when the prosecutor, or when the judge declared a mistrial.
You might win. A Ginther hearing might go your way. I was trying to give you we could get to a Ginther hearing, and the defense lawyer could take the stand and say, I just didn't know about that whole double jeopardy thing. That sounds pretty good. I guess I should have raised that because I would have, saved my client a lot of trouble. But I didn't know. And then we might say, oh, you have a winning ineffectiveness. But I don't have the record either way. So I feel like I need a Ginther hearing.
Okay. Well, this court certainly has discretion to order a Ginther hearing. That's well within its overall discretion in the interest of justice if it needs that to expand the record to decide a case. But I don't think you need one here because even under the more generous standard of the Sixth Circuit, the circumstances in the record must positively show consent. Not that we can draw one inference from many, but that it must positively show consent.
Okay, that's one way to slice this apple. And I mean, I agree with you that our case law, Johnson, should be thought of as waiver as opposed to forfeiture. But there are two ways to overcome the default presumption of double jeopardy once the jury's been impaneled. One is consent, i.e. waiver, and our case law says you can't do that silently. But the other is manifest necessity. And implicitly, since the judge declared a mistrial, the judge must have been making a finding of manifest necessity to which counsel did not object. So can't you, even if you can't forfeit consent, right? You can't consent by forfeiture. You must consent by waiver.
I think I know what you're saying.
Why don't we evaluate whether there was manifest necessity under the plain error doctrine, which actually you say we should.
No, that's exactly, I mean, yeah.
But you don't analyze it under plain error. You just say there was error.
Okay, well, if the brief wasn't clear, I apologize. We certainly acknowledge that the plain error standard of review applies. We certainly acknowledge that this court is limited to what's on the record. But what we do have on the record is the judge saying, this jury's tainted, which it wasn't. And we have the prosecutor saying, hey, judge, don't fix this. Or if you do fix this, it's going to hurt my credibility, which is clearly not manifest necessity. That's a jury question. That's what the jury is called on to do every day. Look at the witness, see if they lied, see if they contradicted themselves. So the judge did articulate. He said the jury was tainted in response to the prosecutor's argument saying, implying at least that corrective measures would hurt his complainant's credibility. That is not a basis for a mistrial.
But so your view is the defense counsel had no burden, didn't have to object before the retrial by written motion or just stand up in court and say, whoa, 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 everybody, there's this double jeopardy thing. I don't think we should be doing this.
Right. He
didn't have to do that because we have enough on the record when the mistrial was granted to say there was no manifest necessity. So under plain error, that's good enough. You don't care about this hole in the ineffective. I think there's a bit of a gap in the evidence on the IATC claim.
Well, to be honest, I don't think we need to get the IAC. And
so that's why you didn't ask for a Ginther hearing.
Because the existing record supports it. The existing record supports a finding that A, there was no consent under this court's jurisprudence, and B, that there was not manifest necessity.
Well, reviewed for plain error, give us your best, hum a few bars on how reviewed for plain error.
On the issue of manifest necessity?
Yeah.
Well, to follow up what I said to Justice Larson, the only articulated basis was for the mistrial was, A, that this prosecution witness may have fudged on some collateral matters. may have fudged her testimony. It's not even clear whether she was lying or perjuring herself. Now, they made a big deal about, People versus Ferranda Smith, and that this, the prosecutor has a duty to correct false testimony. But that duty is fulfilled once it's disclosed to the judge and the jury. And so that's, I think, is a red herring. Because what was exposed, what was disclosed, was evidence that was relevant and admissible to attack her credibility.
But I feel like you're arguing about whether the trial court, when we're reviewing it for plain error, like, how about, those tougher prongs? It's not enough that, it was just the wrong decision, right? When it's unpreserved. Right?
Yeah. That a different outcome would apply, or the interest of justice, or the
that
justice.
one, prong 4, yeah.
Yeah,
However
you gave the prosecutor a do-over. You gave the prosecutor a do-over because your case was going wrong.
And
that sends a very...
in and of itself is, undermines the whatever blah, blah, blah.
So in other
whatever
words...
blah, 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 I think how it's
but here's the problem. If we're going to be in that position, and unlike in federal court where they don't have this strict waiver rule, right? You can sort of, if you fail to object, that can be deemed consent.
Yes.
In our court, that's not true. So I understand that defense counsel might read that and say, like, well, I don't want to consent, so I will be quiet. Okay, fine. But if we also then say there's no necessity to move before the next trial to make a motion saying, well, we can't try this case again because of double jeopardy, what we've said is if we would have determined at the time, had there been an objection, that a mistrial was not manifestly necessary, you're in no worse position for failing to alert the trial judge of that than you would be if you had. In fact, counsel should never say anything, is what you're saying. Never alert the trial judge of a problem, because you're in a better position on appeal if you don't, and you don't make a record. How can that puzzles me?
First of all, that's exactly what Perinis and Carter says. That if there's no input from defense counsel either way on the subject, it's forfeited error. This is not any different, really. There's no reason to treat this differently just because it's double jeopardy. In fact, there's reasons to treat it more protective of defendants, because we've got Dennett saying, hey, first and foremost, we got to make sure that the defense has primary control over the course of this case. So I don't know if that answers your question totally. And really, I don't think the law is completely clear on whether a post-mistrial, pre-second trial motion to dismiss is necessary to preserve the issue. In fact, Johnson and Bennett says the opposite. Says the defendant must do something positive to express consent, to consent to the declaration.
Consent, right.
So at the very
But not to object. There's still this other prong. Like, you still have to object to the ruling that there's manifest necessity.
We are on appeal, for one thing. And under Carter and under Perinis, if there's an improper instruction that wasn't objected to at trial, we raise it on appeal or in a post-trial motion saying, hey, there was plain error.
Right, but on your theory, since the outcome of a successful double jeopardy motion will always be that your client can't be retried. There's always going to be, if we find there is double jeopardy, or then obviously your client was prejudiced. Your client shouldn't have been tried the second time. So what you're essentially saying is counsel should never object contemporaneously when there's an issue of double jeopardy.
Let me say
right, because if you open your mouth, you might be deemed to have consented, depending on what you say. If you're silent, you won't have been deemed to consent, and there's no need to lodge a contemporaneous objection because our plain error review will look exactly like our review would have looked if we had decided it, if we were in the trial court deciding it. So.
And if you keep your mouth shut, you get to have another trial that you might win.
You might win.
Yeah.
You might get acquitted.
Well, first of all, let's address the sandbagging, because I think that's what you're getting at. You're getting at sandbagging.
Yeah.
I think we can all agree that if this court had followed what this, trial court had followed what this court said in Johnson, which is it's not hard to figure out and ask the defense if he consented, and said 3 words, counsel, do you object? That's actually 4. But do you object? We wouldn't be here. And if this court wants to establish a rule that says, instructs trial courts, that whenever a mistrial is on the board, that he or she must consult with both parties and get their input and find out if they object, that would solve this problem. I'd be standing here spending all my time talking about manifest necessity instead of whether
Right.
there was consent or not.
We should have
right?
that rule, though, by the way, shouldn't we? It's sort of.
Yes, because it serves,
But anyway, keep going.
it serves a second purpose, and here's the second purpose. A judge consulting and getting input from the parties on the issue is evidence that he or she is exercising sound discretion. In fact, Arizona versus Washington says that. So it's also an aid in an appellate court reviewing it, deciding whether there was sound discretion exercised. So yeah, it's a sound rule. It's a perfectly sound rule. But what we had at the time was, hey, you don't have to do anything. And even the most competent counsel was at the very least entitled to rely on that. And I'm not saying that the counsel in this case did, but when we're looking at how to interpret silence, whether we should go one way or the other, whether we should look at motives, an overriding factor in this case was a rule that said you don't have to object.
Yeah, but I'm still thinking that conflates 2 different issues. Yes, we have a rule that says your silence will not be deemed consent to a mistrial, will not be deemed to have waived your double jeopardy claim. Mm-hmm. Nonetheless, when the trial court says there's manifest necessity here, mm-hmm. I don't know why that claim can't be forfeited. You say it can be forfeited, we'll review it for plain error, but then you don't want our plain error review to look any different than our review would have looked if he had lodged a contemporaneous objection. And that's my concern.
Okay. Well, sometimes that's just the way plain error stands out. In fact, the existing record is what the record is. And I don't think there's anything this judge could have added to this record besides his claim that somehow this jury was tainted by the disclosure of relevant evidence on credibility supporting a mistrial.
Your time,
There just
your
isn't.
time
I mean,
is up, Counsel. Your time.
Okay.
Are there any further questions?
Can I just add one thing?
No,
Okay.
your time is up. You've gone significantly over. Are there any further questions? Okay. Thank you.
Good morning, Your Honors. Mark Kneisel for the people of the state of Michigan, representing the Appellee. There was no abuse of discretion, let alone plain error, for the mistrial. There was no ineffective assistance of counsel. Both of those things dovetail into what is the more jurisprudentially significant aspect of this court's MOA order, which is whether mere silence or failure to object to the jury's discharge is not such consent is an accurate statement of law. It is not, and this court should disavow it. Regarding implicit consent, the test should come from whether the defense maintained primary control, which is from the Dinnett's case, which has been discussed. Given the myriad motivations for and methods of exercising control, the best way to adjudicate the question of control encompasses the totality of the circumstances, before, during, and after the declaration of the mistrial. A totality standard will also be best suited for future unpredictable ways that mistrials come up in the state. The strength of a control-focused inquiry is that it best serves the protections inherent in the double jeopardy clause. The defendant's anxiety, it's all from the defendant's point of view, so defendant should be the one who's able to exercise and maintain control. At the same time, the defense must not be permitted to exercise its control to the point of harboring error. Objectively speaking, silence can be the method through which one both exercises control and harbors error. Therefore, reviewing courts must be free to assess silence within the entire context of the proceedings in order to protect the fairness and integrity of the proceeding and society's rights in that regard. Therefore, within a totality test, this court should also consider at least a presumption that when the defense does not promptly and explicitly object, it consents.
Hey, counsel, would you agree with your opposing counsel that a better way for us, I mean, one way I guess we could articulate a different or better standard in this opinion, or we could have a court rule that tells trial judges to ask both sides. Do you agree with your opposing counsel that that probably is a better way to handle this?
I don't because, well, yes, that would be okay, but someday a trial judge is not going to follow the court rule, so we still need a way to gauge either consent or both consent and manifest necessity, I submit.
Okay.
So,
well, putting aside the consent issue just for one moment, how do we think about the manifest necessity issue? How do we review it? What is our standard, and how do you think we should think about that issue under that standard?
right, so it's plain error, and it's the abuse of discretion that would have preceded that plain error is subject to a sliding scale. This is not, this is more akin to a hung jury than it is to
Wait, that just got more
prosecutorial
complicated. You just said it's plain error, abuse of discretion, sliding scale. What's my reviewing standard?
Plain error.
Okay. And under plain error, why does the defendant lose? On manifest necessity, just put aside the consent for a second.
Because it wasn't error. Because it's clear from the record that the trial court had considered, they had a chambers conference, they'd had a bench conference, and I know I just said plain error, but now I do have to go back to discretion. In circumstances of spoiled juries, trial courts' exercise of discretion is entitled to the most deference. They are the only ones who have an ability to step in from what's potentially going to be an unjust acquittal. We can't appeal those.
I'm confused again. You said my reviewing standard is plain error. I think I know what that says under like our Carines. Your best argument for why we should say that there was manifest necessity here.
If there was error, it was not plain.
Because,
Okay, why not?
Because
the trial court's exercise of discretion is entitled to the most deference of the available.
And
So
the
you're not-
discretion used here is entitled to that deference because, you have to connect it to what happened.
Because it was a spoiled jury that was not the prosecutor's fault. In fact, the trial judge credited the prosecution for bringing it to everybody's attention. They talked about it at least twice, and then a lengthy, and by the way, the lengthy recap by the prosecution prior to the mistrial declaration, the prosecution said, before you make the ruling, not before you rule, before you make the ruling, and we respect what the court's going to do. Which suggests,
Okay, so maybe the attorney should have objected at that point. They didn't. So now we got to figure out whether there's plain error. And it sounds to me a little bit like you want to say, if the reviewing standard is abuse of discretion, there can never be plain error.
no.
Okay, good. So why does this fall outside of the range of principled decisions? Or why doesn't it, I guess?
Because the various ways that the trials go sideways, that then get to a point of mistrial, no mistrial, sometimes are prosecutorial goading, prosecutorial misconduct, judicial goading, judicial misconduct, judicial error. And the other end of the spectrum, I think, is the hung jury. But near that end, not all the way to that end, but near that end is a trial court's determination that the jury is spoiled.
Why would the jury be spoiled by the suggestion that one witness had given rise to some questions about her credibility? I mean, juries confront that kind of question on a routine basis every day of the week. What's so special about that?
I don't know,
How does that
Judge.
call into question?
I don't know, and it's up to the trial judge. The trial judge does not have a record for declaring mistrials willy-nilly. He's since retired, so there's nothing there. But the proof of the pudding's in the tasting. The judge found that the jury was tainted.
And
no-
then that's
So
under-
then we're done, then there's no, we might have an easier job, I guess, if we never have to think about whether the judge is right about that, my job just got a lot easier, and I appreciate that.
And if there were further record, but the defense does not want to make that further record, because they're harboring error or otherwise exercising control, which is the implicit consent to the mistrial in the first place. This is a defendant who was going to have witness problems. And I brought that up in the brief.
Right.
And so now he's, for all we know, the defense trial counsel didn't believe there was manifest necessity in his own strategic head, but did believe, whew, thank goodness. And now I'm going to sit here, do nothing, and then get my case all the way up to the Michigan Supreme Court because it's so contemplated, and I might still win this case because I harbored error.
But counsel, is that what you think he really thought? Like, that was his strategy?
I do think that at the sentencing, he referenced what he did not do.
But in the heat of the moment, like, is that what
I don't
his
think he
strategy
thought.
was?
I don't think he thought about this court. I beg the court's pardon. But I do think he thought, thank goodness, I can now get my witnesses in.
So this
Absolutely.
is the problem. We can't know. We can't know what happened, and we can't know what was in the attorney's head, whether he was harboring error, or whether he was ineffective, or whether he was operating in all good faith and competence. We can't know because we don't have this record. So do you want to say, failure to alert the judge at the start of the next trial, failure to alert the judge that there's a double jeopardy problem here is tantamount to a waiver that can't be reviewed on plain error? I mean, that almost sounds like what you're trying to say here.
So I guess if I can take that question and wrap it a little bit back with Dinitz, which is another thing that Dinitz stands for is that our traditional concepts of waiver and forfeiture don't really fit into this kind of control exercising review. I would say that express consent to a mistrial would be mapped onto waiver, and implicit consent would be mapped onto forfeiture. But once we figure out that it's implicit consent, using the same factors we would do to do forfeiture, once we've decided, we can tell from the totality of the record that he implicitly consented, then there's no double jeopardy violation in the first place, so we don't even need to go to, which gets back to plain error, which is there was no error. If he consented implicitly.
But the only way he could not implicitly consent, on your theory, the only way he could avoid implicitly consenting is by objecting.
Objecting.
So, in other words, you must always object, or you lose. You can never win on plain error.
I don't think that is always true. I think
when isn't it true?
There will be times when, and I guess I'd like to get back to one more point, which is, we talk about this sua sponte mistrial, which I am guilty of sometimes equating with sudden. This was not sudden. This was not a judge saying, this trial is crazy, I'm out of here, mistrial, and running off the bench. One of the cases in the brief was a judge whose mother-in-law had passed away that kind of suddenly. That kind of total bright line rule, I think still runs into trouble with the unpredictable things that can happen in jury trials. But I do think a presumption in that regard is fair. And it allows for the control of the defense.
Where do you disagree with opposing counsel that what I'll call the Federal Circuit test or the acquiescence test is incompatible with Dinitz because Dinitz focused upon the entitlement that a defendant had to retain what it called primary control over the course to be followed in the event of such error? How is the acquiescence test compatible with that somewhat confusing direction of the U.S. Supreme Court in Dinitz? What does that mean? How do you retain that control if by merely doing nothing you're the subject of an inference that you've consented?
I think that still comes back to the requirement to review the totality of the circumstances. What were the opportunities to object or not? What was the motive to object or not? And so I know I keep on coming back to this, to a totality test.
Well, that is a different test than the Sixth Circuit test, isn't it? Sixth Circuit test imposes an obligation to show on the basis of the totality of circumstances that there are affirmative indications that the defendant intended to consent, right? And that's not part of the test that you're urging.
I don't think there needs to be there's no requirement that there be any sort of affirmative manifestation from the defense, because then we'd be back to an express consent is the only test. I think that the federal circuits, the Fifth Circuit has a draconian rule that says it's all on the defendant. If the defendant does not object right away, then it's consent. I think there's too many ways that trials go sideways, but I do think that the presumption that if a defendant is silent, and it's not just the defendant personally, it's the defense, is silent, then that's implicit consent.
Well, this court isn't bound by any of the circuit court tests, but we are bound by the Supreme Court test. Tell me, please, summarily, what it means for the defendant to retain primary control over the course to be followed in the event that there is an arguable double jeopardy, that there's manifest necessity.
I think what it means is that a reviewing court must look at the entire record before, during, and after the moment of the mistrial. I think the reviewing courts should look at the opportunity to object, which will almost always be able to be gleaned at least a little bit from the record. Here we had a
Well, you're
chambers
just giving me your
conference.
test. My question for the third time is, what does retaining primary control on the part of the defendant mean?
It means he's the one who's deciding whether he wants to have this trial or the next trial.
Okay.
And here he wanted the next trial with his witnesses. So because of that, I do think this court should first disavow the Johnson rule, because it only takes a snapshot in time instead of the totality of the circumstances. Should adopt a totality approach and a control-based approach, and in whatever way affirm the defendant's conviction, unless there are any other questions.
I'm sorry.
Yes.
So if we're going to overrule Johnson, which is what you want us to do, how do we think about stare decisis?
I believe the court can disavow the rule in Johnson. I don't believe it was holding. I believe it was dicta. I believe it was wrong when it was first decided, which is the first stare decisis.
Yeah.
And I believe it's really not been followed. And the best thing about the Johnson test is that it helps defendants harbor error. So any way to get rid of that, I think, advances this court's jurisprudence.
Counsel, I just am a little curious about the ineffective assistance of counsel. And I guess my question to you would be, what is the trial strategy in not objecting? How does that benefit my client if I don't object to a situation like this? I'm just trying to think, what possible benefit do I get by not making an objection on the record in this situation?
On the particulars of this,
Yeah.
On the particulars of this case, the benefit he gets is a new trial with his witnesses and the ability to harbor error. That's what's going on here. Defense counsel they don't want to say mistrial, because then they can pull it out of their sleeve later. And that harbored error has got to be.
But if you win that, but if it's a double jeopardy situation, ultimately, and you place that as an objection, I mean, and the judge holds, before the trial begins, that the trial can't take place. What's the benefit of not objecting?
So if I hear your question correctly,
Yes.
It's to bifurcate. He didn't object at the time that the first trial terminated, and then he didn't object.
Correct. Yeah.
Or move before the second trial. And the reason is because if he wins or loses, if he wins the double jeopardy argument before, then we still litigate this for months and months and months, and he may lose. Instead he goes straight ahead to a trial with.
But if you place, I'm just trying to follow this. But if you place the objection and you say, look, Your Honor, I object to the fact it's double jeopardy right now, and we shouldn't have the second trial. I'm still at a loss as to why you wouldn't. I mean, look, as a litigator, I used to argue everything. So I guess my question is, I'm still at a loss as to why not make that intense argument before the second trial goes forth? What is the downside to putting your objection on the record and fiercely advocating that there is double jeopardy right here and that we should not have the second trial?
The downside is that the trial court recaps everything that happened at the Chambers Conference and says, remember when the prosecutor said, we respect the court's decision on what the ruling is going to be, and then there's no issue on appeal, which actually I would have been fine with too, but
But there's no certainty of
Harvard
that.
error.
I mean, you could still win the objection. I guess that's my point, is that, you know,
And then we would have appealed, the prosecution would have appealed, and maybe prevailed, and he would have had a trial a year and a half later. Instead, he could go right ahead to hopefully get the blue ribbon standard of double jeopardy, which is a jury acquittal, with his own witnesses.
Counsel, can I ask you about the Johnson test again? I understand that the dominant approach to giving meaning to that test in Michigan has been that mere silence or failure to object is never sufficient to indicate consent. But I mean, it seems like there's a broader potential view of Johnson too, which focuses on the mere silence or failure to object, namely that in conjunction with other factors, the silence may be sufficient to infer such consent. And if in fact that broader view is the better understanding of Johnson, how does Johnson differ at all from the Sixth Circuit test, which seems to say almost exactly the same thing?
I think if you take the word mere, or the gestalt mere, out of the Johnson dicta, we would find ourselves very much in what is going on in the circuit courts, which I think would be an appropriate path going forward.
Any further questions? Thank you, Counsel.
Thank you.
You don't have any time, but let me ask you to come back up here. You had one more point. I cut you off a little bit too summarily. Why don't you make that one more point?
Prosecutor had two chances to make a record on whether there was consent at those sidebars or whether even a mistrial was even discussed. When the mistrial was first declared, he put what was on the record. We go on the record, as I said before, we go on the record and make a record of what was said at a sidebar and in chambers for the very purpose of this court figuring out what went on. He didn't mention mistrial once. He said, your ruling can include, a curative instruction or barring the witness from testifying further or a stipulation from the parties saying that this testimony was false. There are many different rulings. Ruling doesn't mean I'm going to declare a mistrial. So the prosecutor did not mention mistrial or consent or waiver or anything like that when he put it on the record, nor did the court. Now let's fast forward to sentencing, pages 8 and 10 through 14 of sentencing. Defense counsel went to great pains to say, I didn't consent. I didn't waive, I didn't consent, I didn't do anything. What did the prosecutor do? He didn't dispute that. So if we're going to look at silence, if we're going to say silence is evidence of consent, silence in the face of an affirmative assertion about a fact cuts against every argument they've had on consent. I don't know, do you get the sentencing, you get all the transcripts and a MOA? Okay, all right. So I would just urge you to go through page 10 or 8 and 10 through 14.
Thank you, Counsel. Thank you. Case is submitted.